Intellectual property and technology have been resolved through arbitration for many, many years now. And I have been told by a few members who are present today that they feel that it's perhaps not as well used in India as it could be, and that it's probably more used abroad, but our panel will discuss that through the course of the conference today. Arbitration is something like a court proceeding but behind closed doors. And an arbitrator is somebody who does act as a judge, and what he or she determines is an award which is enforceable, as I have previously said, which distinguishes it from a mediation. This award is enforceable in a court so long as it is the final award in an arbitration. So interim awards, especially in international arbitrations, are not enforceable. And unlike a judgment of a court, in an arbitration, the award is only binding between the parties to the arbitration. So this is something that one needs to consider when one is determining whether or not an IP dispute especially should be arbitrated, because it's only going to be binding between the parties to the dispute. So if you really need a remedy which is against the world at large, then perhaps arbitration is not the mechanism for you, and it's the courts that one should go to. That said, the courts are able to grant ancillary reliefs, so they are able to grant interim reliefs in support of arbitrations, and this is something that I would encourage those parties going to arbitration to sort of accept and go for. And the reasons for this is because when an infringement is detected, the rights holder often feels that he or she needs immediate interim reliefs pending an arbitration, and that immediate and urgent relief can only be granted by a court, which can be enforced against the world at large. The types of reliefs include, for example, seizure of the infringed documents or products and so on, and also sometimes freezing injunctions, and these can also be worldwide freezing injunctions. Now, although interim reliefs can be granted by courts, they can also be granted in an arbitration. And increasingly, a lot of arbitration institutions around the world are bringing within their rules emergency arbitrations. So these are distinct from expedited arbitrations. In an emergency arbitration, parties can go to the institution and say, we are going to submit this particular dispute to the arbitration, but we would like for this particular issue to be determined immediately because we have found that there has been an infringement and we need immediate rights. So in these circumstances, an emergency arbitrator will be constituted, and this arbitrator tends not to continue as the main arbitrator in the final arbitration. And very quickly one is able to get, and some rules even go to the extent of saying that they will constitute and have an emergency arbitration heard within 5 days of receiving a request from the parties. So that is fairly quick, but remember that if it is an emergency arbitration award which is passed in an international arbitration, it will not be enforceable in any country other than the country in which it has been passed. So for example, if it is in a, hello? Check. If it is in an arbitration seated in London and an emergency arbitration award has been passed, this will not be enforceable if you need seizure of goods in India. For that, one will need to go to the courts in India to get the interim relief which is necessary to support your arbitration. That is not to say that one should be deterred from the arbitration process entirely, but to use the court mechanism as and when one needs to support the arbitration proceedings that one wants to go forward with. Now, to enter into an arbitration agreement, what does a party need to do? Most of you, especially those who are lawyers in the audience, will know the a default dispute resolution clause. So this is one of the many clauses in a contract which says that in the event of a dispute, the parties agree that the procedure which is set out in that clause will be abided by. So for example, if it says in the event of a dispute, we will go to a SIAC arbitration seated in Singapore, that's what the parties will do when a dispute arises. Now, there are certain, in my experience, certain sort of tweaks that I would make to a regular dispute resolution clause when one is contemplating in particular an IP or an IT dispute. And these include that the arbitrator should have subject knowledge expertise. It's quite important, and I find it very useful when the clause itself requires that the arbitrator will need a subject matter expertise. Then the second is that all disputes should be heard in one forum. Again, in IP and IT disputes, especially cross-border disputes, there tend to be parallel proceedings across different countries. For example, there may be a court proceeding in one country and arbitration in another, and so on. Now, to avoid this, which is, as we know, risk because it can come up with irreconcilable judgments, it would be useful for the dispute resolution clause itself to say that all disputes will be subject to one forum. Now, there is law on this, and the English, I'll speak about English law because there are a number of others on the panel who are going to speak on Indian law. Under English law, there are actually two lines of judgments. One is the Satyam Computers judgment, and actually the Satyam Computers is a judgment of the English High Court. And it says that one should look at the document which is at the commercial center of the transaction. So sometimes, and again, especially in technology disputes, one tends to see it may be a licensing agreement, a technology transfer agreement, and a joint venture agreement, and a number of other documents. And they may each contain separate dispute resolution clauses. And so this judgment says that one needs to look at the dispute resolution clause in the agreement which is at the commercial heart of the transaction. So that is going to prevent parallel proceedings. And another line of judgment says that it's just assumed that common businessmen, and at that time we want gender neutral, so it didn't say business women as well, but basically business persons would have envisaged their businesses or their disputes in such a way that they would want for it to be resolved in one forum rather than more than one forum. So that is a separate line of judgments as well. And then there is a third which holds the view that if there are multiple documents and the documents contain different dispute resolution clauses, then there is a risk of irreconcilable judgments, but that is just the risk that the parties have taken. So to avoid all of this and to avoid parallel proceedings, I think it's very useful in IP and IT disputes to have the clause, the dispute resolution clause in your contract, say that all of the disputes will be resolved in one forum. The third is that you can also say that only one law will apply to all disputes. So even, for example, if there are parallel proceedings, only one law will apply. So for example, you can say Indian law or German law, it depends on what your matter is, will apply to all of the disputes. And that includes if you need an interim protection from the courts in India, you ask the Indian courts to apply the German law if that is what is required of the transaction. The fourth is that the parties agree to incorporate the terms of an arbitration award, whether interim or partial or final, into their agreement with effect from the date of the award. This is useful because, as you may recall, I previously mentioned that interim awards in foreign arbitrations are not enforceable anywhere outside the country of the seat of